All right, now I'm going to bring this one up, Robert, because we had a discussion about this. Cleopatra561 says, it was a spirited day on vivabarneslaw.locals.com today. Israel's right to defend itself. Most people agree Israel has the right and is not the aggressor. Look at skynewsaustralia.com today for only right news on the subject. And Robert and I said, there are some subjects where there's law and politics, some subjects where there's just law, and some subjects where there's just overwhelming politics where it's never going to go anywhere good. So I said, that discussion, we can have that on Locals on YouTube tonight. We'll stick to the law and politics, but mostly law stuff. And I got a couple of emails and messages about the lively chat discussion. It's just a discussion. You know the way it goes every single time. I would say that an analogous thing that happened to me once when I was studying philosophy, and I thought you could have a philosophical discussion on schmortion issues at a house party. You can't. Don't. It just ends in tears, and you end up going home not fully appreciating what went wrong, but just knowing something went wrong. So.
That might be a good transition into the Supreme Court did take up the Mississippi abortion law case. And what the case is going to Mississippi passed an abortion ban after 15 weeks. With exceptions, but limited exceptions to when you could get an abortion after
those exceptions. Weeks. The exceptions, I presume, are rape, threat, risk to the woman, risk deformation of the baby.
No, it's more certain public health risks to the woman.
Okay,
not really specific to those other ones because the belief is you could get the abortion prior to the 15-week time period. Okay. So the main issue they're challenging is right now. There's an interpretation lower courts gave in this case, which was that any law that restricts abortion prior to the viability of the fetus outside of the womb is presumptively unconstitutional, is what they argue. And they're arguing that legal principle no longer makes sense with the existing medical knowledge. So there's two main questions that the court will be facing. One is, when is someone a person? Or legally in this context, when does a state have a strong interest, a compelling interest in the life of the fetus? And the second one is, who decides that question? In other words, maybe it's not for the court to decide that question. Maybe it's something that the states should be able to decide on their own. And the Mississippi's argument to the U.S. Supreme Court is that they should revisit the viability doctrine, that any pre-viability abortion limitation is presumptively unconstitutional, that they should just scratch that altogether. Instead, say that the state, with the modern state of medical science, that states have the right to make their own public health determination once the fetus reaches a certain stage of sentient awareness of pain, neural capability, brain activity, etc. And that reflects sort of the developments of, we know a lot more about the mental and physical state of a fetus now than we did when Roe v. Wade was decided in 1973.
Now, this is one of the ones that I was not able to read. Who's filing the lawsuit? Which is the party filing the lawsuit?
That's the other question. Abortion providers sued the state of Mississippi after the law was passed. Mississippi is challenging their standing to sue. Now, people know, even though, people may perceive I'm on the pro-life side of the equation, I disagree with the state of Mississippi on this because, like I say, in all standing cases, standing is a bunch of gibberish and is just a made-up, invented doctrine, and I apply that no matter who it benefits or hurts. So, but that is the second part of the state of Mississippi. So the state of Mississippi was sued. They lost in the district court. District court said, no, this is a pre-viability abortion ban, presumptively unconstitutional. You didn't overcome it. Law unconstitutional. Went up to the federal, what circuit was that? I was going to say, I thought it was a 6th Circuit, but I'm not certain. The came in and affirmed the district court decision. And they petitioned the U.S. Supreme Court to take it. The U.S. Supreme Court's been dodging abortion cases now for a while. They kept dodging this one. They kept bouncing it. Now, I mean, they weren't saying no. They just were bouncing when they were going to. And then today they announced they were taking it. And my guess is it would not have been taken. This is an area where, for those that are on the pro-life side of the equation, or on this side of the equation in terms of states' rights or however they perceive it, where Barrett was probably an ally. My guess is that Barrett is indicating that she will say that the pre-viability abortion ban being presumptively unconstitutional did not make sense and doesn't and won't going forward, and that they will likely say there's a compelling interest in a fetus life, probably from at least the 12th week onward. And this kind of reflects also a lot of international law. And international law, there's a lot of places where the first trimester abortion is very legal, but after the first trimester, a lot of places do not make it very legal. So, and this includes people that are considered liberal democracies in Europe. So the smart thing that the pro-life community's done is they've brought in the medical science. They've labeled some of these bills heartbeat bills, things like that, things where there's a lot more public sympathy. The public opinion generally favors abortion rights in the first trimester, generally is conflicted about the second, generally opposed in the third.
Yeah.
And so that's, I think now people that think they're going to say reverse Roe v. Wade entirely, and say that in fact there's a right to a personhood from the time of infertilization, I think they're wrong. That I don't see that happening, even though there's a strong Catholic bent on the court, and that's the official Catholic Church position, that life begins for personhood purposes under the 14th Amendment as soon as there's infertilization. Generally speaking, the courts haven't gone in that direction. I don't see them making that dramatic a move. Though, again, Kavanaugh and Barrett do come from religious conservative constituencies, as well as Gorsuch. Thomas and Alito have already hinted at they would overturn Roe v. Wade. I don't think Roe v. Wade will be fully overturned. I do think they will overturn. I think they will start saying that second trimester onward, you can completely ban abortion in most circumstances.
Okay,
and
now
whatever you think about that, they'll say states have the right to do so, not that the states have to do so.
Okay, that was what I was going to say. So, I mean, the ultimate outcome in this would be to strike down a portion of this particular law, and then.
I think they'll affirm this law entirely and reverse the lower courts. But that doesn't mean they're saying every state has to have Mississippi's laws. They're just saying states can pass Mississippi's laws. Okay, interesting. And that is now the Mississippi law itself outlawed abortion after 15 weeks. Correct. With one or two exceptions for like some form of health, and there was another one too.
Okay, now the 15 weeks, that date is, I forget what the
medical literature. 15 weeks.
What the youngest viable premature baby has been born at. Someone in the chat can help us, because I know it's.
No, they don't tie it to viability at all. They wanted to challenge the viability argument. They're acknowledging that this is not tied to viability. Instead, it's tied to brain activity, sentient activity, the ability to feel pain outside the wound, as well as the heartbeat and organs.
Okay. I mean, this is another one of those debates where extremes on both sides, but when you hear some of the extremes on one side, and I think it was Norfolk, was it Governor Norfolk talking about...
we put the little babies and we swaddle up the little babies, and my good friend does a very good imitation of the governor. Dear Governor Blackface.
No. This is where when you hear some of the extremes, and where you hear where that slippery slope can lead, and when you learn about other industries which a lot of people don't know about, and when you learn about certain things, it will cause you to question things that you might not have otherwise questioned. But that's interesting. So time frame again for these things with the Supreme Court. They've agreed they're going to take it up, hear it, and render a decision by end of the year.
You don't know. I mean, because normally, but what happens next is briefing. So both the merits briefs. You first file your petition for cert, begging for them to take it. Then they afford merits briefs. I'm sure there'll be tons of amici briefs on this on both sides, all sides. And we'll see how many they take and accept, but they'll probably take and accept a bunch. And I think the broader belief that it's going to overturn Roe v. Wade is likely mistaken. Not impossible, but likely mistaken. I think they're going to come in with what's been become the international norm but I think they will scrap the viability standard. The only reason to take this case is if they were going to scrap that standard. And I think they are going to scrap that standard. But I think they'll establish a new standard that gives states the rights to limit abortion from the second term onwards, because that's what this really poses, from the 15-week period onwards.
Well, I mean, it is. We've discussed the apparent contradiction in certain concepts where states that have robust abortion laws or very lenient abortion laws also sometimes recognize murder if something happens to a pregnant woman.
There's a lot of legal confusion in this space. I mean, similar there is on, age-related issues. There's a lot of legal confusion. One minute we treat somebody as an adult, the next minute we treat them as a kid. There needs to be legal clarity in this space. My view is, or what I think is the correct constitutional doctrine, is that states should have the right to be able to limit abortion and from the second trimester forward. That's my own personal view. I do think this court will actually come to that same decision because sometimes they make the right decision.
And the one thing we might want to do for another day, if it's too long now, is actually go over the Roe v. Wade in some detail, because I think it's among the more.
It was a crap decision. It was deference to the white lab coat crowd. It was not well rooted in constitutional law. Now, I don't agree with some of my conservative friends. I absolutely believe the Fourth Amendment includes a right to privacy. I mean, that's just nuts. To me, the question has always been, when is someone a human person? Because then you have two different lives at stake. And you have to deal with that meaningfully. And my own view has always been that we should count life and death the same. And right now, medically, we consider you dead when you're brain dead. So once there's real brain activity, how do we not call that life when we call it life before we'll allow someone to be declared dead? That's my own view. Though I do think I've always viewed that this should be a state issue. This should not be a federal issue.